Matthew, thanks very much for agreeing to chat to Mining Weekly Online. There is a lot of confusion and controversy around the MPRDA, and now we seem to be entering another minefield. Could you just give us some idea of the state of play of this legislation?
That's exactly right. We are sitting with a situation where we have, over the last 7 or 8 years, come to terms with a difficult act which changed the law to a great extent. Proposed changes to it were put forward in 2007, 2008. Those were just shelved indefinitely. Everyone thought they'd gone. Then they were suddenly brought into force in 2013, a couple of months ago. And at the same time, further amendments were proposed under the 2013 bill, which is now sitting in front of Parliament. That's probably going to have an equally long passage through the parliamentary process, simply because a lot of the amendments it proposes are fairly complex and far-reaching, and because of the consultation process that has to take place, I think there's going to be a lot of representations made about the various changes, specifically those relating to transfers of rights, beneficiation provisions, as well as these provisions which are purporting to make changes to the regime governing mine dumps, and to basically vest the Department of Mineral Resources with the power to take control over who can process the material contained in dumps.
And what is the most confusing aspect of it in your view?
I think what's taken everybody by surprise was the act which everyone thought had, although it had been signed into law by the President some years ago, everyone thought it had died. And there were rumblings from time to time from the DMR that the act was going to be amended somehow differently. Now we're sitting with a situation where we're effectively amending the amendments. And as I say, it's a difficult act as it was. My preference would have been for us to focus less on changing it, because I think the objects are all there as it is, and rather shift to implementing the act properly and efficiently. I think that's where things are lacking. What we're going to sit with now is a situation where we have to Finnegan begin again, as it were, and come to terms with a whole lot of new provisions.
And what impact do you think this could have on investment?
What investors want more in the South African market, and what's put them off investing here, is more things like lead times and implementation. A lot of these amendments, other than the ones that I've already mentioned, a lot of these amendments I think are fine, and they go along. They sort of go along with what the basic driving thrust behind the MPRDA is about. So it's not so much content, although there are a few things which are controversial. It's more, to me, about getting the act implemented properly and efficiently, so people know if they want to come and purchase a mining operation that it's going to take 6 weeks and not 5 years.
And do you think this will delay implementation now? What is happening in Parliament now?
Yeah. I think there's confusion about how the Act must be implemented now, simply because, the environmental provisions, which my colleague will talk about, are, for example, there's a whole lot of things which have been inadvertently, accidentally repealed. So I think implementation is going to be difficult now.
Certain provisions of the MPRDA have been deleted, which leaves portions of the environmental regulation unregulated for the next 18 months. Although the provisions have been deleted, I think that they're going to continue as they have in the past, and everyone's just going to turn a blind eye to the fact that they have been deleted. But if there is a dispute, then it might, and which relate to those sections in particular, it might cause some problems.
With regard to sort of guarantees now,
the provision saying that you've got to have an unlimited amount of liability, even after a closure certificate has been issued, means that you've got liability indefinitely. The 20-year financial guarantee is a significant burden, but there was always that provision in the MPRDA to withhold a portion of money to use it for rehabilitation. But the fact that now that the proposed amendment in the MPRDA amendment bill, if that goes ahead, it's liability for the life of the, way beyond the life of the mine forever, and I think that's not necessarily a possibility.
And are there any positives? Are we going to streamline the legislation?
Once it all has moved to the Department of Environmental Affairs as being the responsible authority, there'll be little less confusion. And to be honest, the correct authority then dealing with environmental issues, that has the environment as their primary objective as opposed to mining as their primary objective. So I think we should hopefully be seeing a better enforcement of mining legislation from an environmental perspective, because the correct authority is with the correct objectives is dealing with it.
And what is the biggest single negative in your view about the framework for environmental and mining at this stage?
I think it's just the confusion that there is the sort of, it's unclear who the responsibility is, and it's unclear, what party is responsible, which authority is responsible within the Department of Environmental Affairs as well as the Department of Mineral Resources. There's different levels, and no one really knows what to do with the environment and with its regulation at the moment, because those provisions have been deleted.